On record, thanks for everyone's patience. I got involved in the matter. Did not think it was going to take as long as it did. So we're ready to move forward. Mr. True, do you want to take Mr. Lovely's case?
Yeah, sure.
Okay. People versus Lovely, file number 25137, 245341, and 25544. Direction reflect Mr. Lovely's present here in the courtroom today. I'd like to have counsel for the hearings.
Your hope on behalf of the people.
Thank you, Your Honor. Richard Trishbury on behalf of Mr. Lovely.
Mr. Trush, how do you want to proceed on these files today?
Thank you, Your Honor. We have a resolution of the matters whereby Mr. Lovely would be making an admission to possession of methamphetamine. The enhancements would be dismissed, or the enhancement would be dismissed. And the same admission will also be the basis on the probation violations.
Let's go with that direct statement of the offer.
It is.
Mr. McFalda, is there, he's going to be the non-technical.
Correct, Judge. I'll dismiss the count one and things to the.
Mr. Lovely, have you had an adequate opportunity to speak with Mr. Trush about this plea agreement?
Yes, Your Honor.
Is that how you wanted to proceed today?
Yes, Your Honor.
Can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
So, Mr. Lovely, you understand that by pleading guilty to the possession of methamphetamine charge, new file, that carries with it a maximum possible penalty of up to 10 years and or a $15,000 fine.
Yes.
And by pleading guilty to that charge, it's going to result in a finding of guilt as to a violation in both of your probation files, which would subject you to the maximum possible penalty in those cases as well, which in file number 225137, which is attempted possession of methamphetamine, that would be 5 years. Do you understand that?
Yes.
And then in the other file would be the maximum penalty in that case would be up to 2.5 years. Unlawful driving away charge and a 1-year misdemeanor on the MDOT charge. Do you understand that?
Yes.
With all of those penalties in mind, what is your plea to each of those charges today?
Guilty.
So right now you have certain rights. I'm going to go through those with you. With regard to the new charge of possession of methamphetamine, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you. And the right to testify at a trial yourself if you want. You understand all those rights?
Yes.
You understand that you're going to be giving up and waiving all of those rights by pleading them.
Yes.
Regardless of your plea in that case, you would still have the right to have a hearing as to whether or not you violated your probation in your 2 probation cases. You understand that?
Yes.
You understand that by pleading guilty in those cases, you're going to be giving up that right as well.
Yes.
Has anybody threatened you with anything to give up any of your rights today?
No.
Has anyone promised you anything other than what you said here on the record?
No.
Is it your own free choice to enter these guilty pleas?
Yes.
Are you pleading guilty because you are actually guilty?
Yes.
I'm going to ask you some questions about the circumstances. Before I do that, there's one other matter that I need to advise you on. The pleas that you're entering today, you don't have an automatic right to appeal your pleas. You can only do that by leave, which means you would have to ask for the Court of Appeals to hear your case. If they said no, then you wouldn't be able to go any further with your appeal.
Yes.
So on on the new charge of possession of methamphetamine, this alleges that occurred on or about May 9th of 2025, is that correct?
Yes.
On that date, were you here in Crawford County?
Yes.
And did you have some methamphetamine in your possession?
Yes.
Did you know if that's what that substance was?
Yes.
Did you have any legal right to have any amount of it at that time?
No.
And at that time, were you on probation in two different files, file number 245341 and 225137 here in Crawford County?
Yes.
Were you aware that one of the conditions of your probation was that you were to not use or possess any controlled substances unless they were
Yes.
prescribed? Mr. Truth, are you satisfied with the factual basis in this case?
Yes, Your Honor.
Or in all three?
Yes, Your Honor.
Ms. Coe,
Yes, Your Honor.
Mr. McDowell, are you satisfied there's a factual basis for finding guilt as the violation?
Yes, Your Honor.
Mr. Truth, are you aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Ms. Coe,
No, Your Honor.
Mr. Truth, are you satisfied that the court has complied with statute before will undertaking of this vote?
Yes, Your Honor.
Ms. Coe,
Yes, Your Honor.
Mr. Lovely, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied there's a factual basis to support a finding that you are guilty of the possession of methamphetamine and of violating your probation in each of those files. The court will accept your guilty plea as to all three. Set this matter for a sentencing hearing, and there'll be a new pre-sentence report that's prepared. And you'll have a chance to go through that with your attorney prior to sentencing. Okay.
Thank you.
Mr. Godating, are you able to hear me okay?
Yes, Your Honor.
All right, and just to confirm, you are Dean Anthony Godating, is that correct?
Yes, sir.
We'll go on the record in People versus Godating, case number 255427. The record will reflect the defendant's present by video from Nuevo County Jail. I get it. Put your hands to that.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Richard Trush, being on behalf of Mr. Golding. Your Honor, we're in receipt of an offer that contemplates if Mr. Golding pled to, I believe it would be added count 3 of, count 3 as a habitual second offender notice, that the remainder of the complaint would be dismissed. I spoke to Mr. Golding yesterday. He intended to take advantage of that. I would indicate he did message me this morning and asked if we could do a breakout room. Frankly, though, that's absolutely not feasible with how far I am behind in both counties.
Okay. All right, Mr. Godating, I'm not going to be able to facilitate a discussion with your attorney here today. So I guess my first question is, without being able to talk to your attorney, are you prepared to enter into that plea agreement here today?
Yes.
Okay. And so that's count 3, which is the Arno.
Correct.
Okay, so Mr. Godating, the plea agreement is that you would plead guilty to resisting or obstructing a police officer as a habitual second. And in exchange for that, the controlled substance possession of methamphetamine charge and the tampering with the evidence charges would both be dismissed, as well as the habitual fourth offense enhancement. Is
Yeah.
that okay? Is that the plea agreement as you understood it after speaking with Mr. Trush?
Yes, Your Honor.
Okay. And Ms. Koch, is that a correct statement of the plea agreement from your standpoint?
I think so. The court said it correctly. The resistant obstruct is a habitual second, dismissing the habitual third and fourth.
And count 1 and 2.
Yes.
Okay. All right, so Mr. Godating, can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you. You can lower your hand. So Mr. Godating, the charge that you're pleading to again here today is resisting or obstructing as a habitual second. That means that the maximum possible penalty you could face would be up to 3 years on that charge. Do you understand that?
Yes, I do.
Are you on any other kind of probation or parole?
I am on, yes, 2 years parole when I finish the 18 months that I'm doing in BOP.
Okay, is he subject to parole violation sanctions for this charge?
So he's on federal release. I say federal release because technically there is a distinction between parole and supervised release. He's already been violated for that, and that's actually what's holding him in Nuevo County right now.
Okay, so he will not face any additional penalties in that case for this plea today.
Correct.
Okay. All right, so Mr. Godating, with that maximum possible penalty of up to 3 years in mind, what is your plea to the resisting or obstructing charge today?
Plead guilty.
Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to have to testify at a trial yourself if you wanted. You understand all those rights.
Yes, I do.
You understand that you're giving up and waiving all of those rights by pleading guilty.
Yes, I do.
Also, you don't have an automatic right to appeal the plea that you're making here today. The only way you can appeal it is by leave. That means you would have to ask for the Court of Appeals to hear your case. They could say no, and that would be the end of any appeal. Do you understand that?
Yes, I do.
Has anyone threatened you with anything to get you to plead guilty?
No,
Has anyone promised you anything other than what we've said here on the record today?
no, I just, the only thing is, I wanted to talk to Mr. Truce about the sentencing and how that is going to, how those sentences are going to lay.
Yeah, Mr. Truce, is there any consecutive sentencing sanctions or do you?
So I kind of addressed that to the court. The distinction between parole and supervised release is very important for that. I think Your Honor had a case in regards to someone who essentially had out-of-state parole. Very similar issue. If it's definite sentencing as opposed to indefinite sentencing, consecutive sentencing won't apply. That's the situation that we have here. He's under a sentence that's 18 months, 12 months incarceration, 6 months in,
Halfway.
sorry, like a work camp program. So he shouldn't have consecutive, or he should not have consecutive sentencing exposure.
Okay, so, Mr. Godating, that means that your sentence in this case would be running concurrent or at the same time as your sentence that you're now serving.
Okay.
Does that change anything about your willingness to enter into this plea today?
No, it doesn't. I just wanted to make sure that was my understanding of it, and that is what it was. That's all.
Okay. All right. Other than that, has anyone promised you anything other than what we've discussed on the record today?
No, Your Honor.
Is it your own free choice to enter into this plea?
Yes, it is.
Are you pleading guilty because you are in fact guilty?
Yes, I am.
The information in this case alleges that this incident happened on or about May 8th of 2025. Is that the correct date?
Yes, sir.
Your Honor, if I could assist with the please. Mr. Godating, on that date, were you here in Crawford County?
Yes, I was.
And you were at your residence at the time?
Correct.
And was anybody else staying at that residence with you?
No.
Was there anybody else there with you?
Oh, yes. She was there with me, yes, but nobody was living there with me.
Okay, who was there with you on that date?
Jennifer Leo.
Right. And had she been staying overnight there?
She had a couple times when there was bad weather.
Uh, On that date, did she give something to you?
Yes,
What did she give to you?
paraphernalia and stuff I was trying to flush.
And you said you were trying to flush it. Did you interact with a police officer on that date?
Yes, I did.
And he was in a uniform?
Yes, he was.
And did he tell you to stop flushing that?
Yes,
And did you immediately comply with that command?
yes, I did. At that point, they put me in handcuffs.
Okay, so when he came in, what were you doing?
I was flushing the drugs. I was drying off actually, but I had the paraphernalia in my hand at the same time. When the door opened, I dropped it and pushed the button.
All right, Ms. Coe. Satisfied with the factual basis?
Yes.
Mr. Godating, had you been convicted? Let's see. Any Michigan?
Mr. Goding, were you convicted of possession of methamphetamine in 2022?
Yes, I was.
Where was that at?
Delta County.
Delta County, state of Michigan?
Yes,
Just to be clear, I think there's a factual basis under two theories here, not following the command, but also I think inherently that action would be obstructing the investigation.
Yeah, I would agree, based on the testimony. So, all right, Ms. Koch, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
If Miss Leal is to go to jury trial, we will be calling Mr. Godating to testify to the statements he made today at that trial. That was part of the agreement.
Okay. Mr. Truce, are you aware of any other threats, promises, or inducements?
No, Your Honor.
Ms. Koch, are the people satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Mr. Truce.
Yes, Your Honor.
All right, Mr. Goding, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied there's a factual basis to support a finding that you are guilty of the resisting or obstructing. The court will accept your plea. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. Mr. Goding, you'll obviously stay lodged time.
Correct. There is one issue that I do want to still address for the court, but yes, he should still be lodged at that
Does
time.
that involve sentencing or the issue that you want to address?
It involves his bond.
Okay, so, Mr. Goding, you would have the right to have your sentencing hearing here in Crawford County. And if you want to exercise that right, the court would sign a writ to have you transported here for purposes of sentencing. You can waive that right and we could still have that hearing by video like we're doing today from where you're at.
yeah,
there.
we can, there's no, I don't see any need to bring me all the way up there. We can do it just like this. That's fine.
All right, Mr. Truce or Ms. Pope, do you have any objection to sentencing by Zoom?
No.
No.
Okay. All right, so we'll do it by video, Mr. Goding. If you change your mind about that, then make sure you let your attorney know prior to that sentencing hearing date, okay?
Okay.
Mr. Truce, in terms of bond,
Insofar as there's a bond in this, I'd ask that it be canceled at this time.
any objection to that, Ms. Pope?
No.
All right, the court will cancel the bond if you can just prepare an order reflecting that, so we have that for the file. Mr. Goding, do you have any questions at all?
No, I don't.
Okay, thank you. That concludes this hearing today, and the court's going to go ahead and disconnect at this time.
All right, thank you.
People versus Clock, case number 255442.
That's my matter, Your Honor. I don't know if Mr. Church wanted to continue with his matter.
If we could address Ms.
Keep
Creed.
going with yours.
Well, if we could address Ms. Creed, then I can take a break and wrap up the Otsego matters.
Okay.
All of them should be up at that point.
Okay, we'll call People versus Tanya Creed, file number 255408. The date and time set for sentencing and direction to collect defense present here in the courtroom. And Ms. Creed, have you had an opportunity to review the pre-sentence report and go through that with Mr. Trude?
Yes.
Mr. Trude, are there any additions, deletions, or corrections to that report?
I know, Your Honor.
Ms. Coe, do the people have any additions, deletions, or corrections?
No, Your Honor.
Any kind of gap people for help?
Your Honor, this is just one of those cases that Miss Creed made a bad situation even worse. Her behavior was terrible. You know, she's only 33 and she has 8 misdemeanors. We did give her this plea offer. I think the recommendation is appropriate. I hope she has learned a lesson from this situation. Thank you.
Thank you, Your Honor. Several things that I would point out to the court. This is a situation where Ms. Creed presents with no prior felonies, no prior assaultive offenses. I would agree with the prosecutor here. It's a situation that I think Ms. Creed made worse for herself. But I think the underlying question that's highlighted throughout the PSI, I think, well, why did she make it worse for herself? And I think the answer is clear. Alcohol. Alcohol was involved in this, and alcohol is a problem. They identify in here, you know, she was on bond for an alcohol-related offense when this happened. That's now been resolved in Roscommon County. Been resolved in Roscommon County. She is getting alcohol treatment now, and I think, frankly, that's the appropriate thing for her to do, is to get treatment for the alcohol. The alcohol, I think, is the driving force behind that, and it's the driving force behind this. And frankly, I think if you look back at her criminal history, it's the driving force behind most of those things. What I would suggest to the court is a recommendation that doesn't involve jail. I would suggest that the more appropriate way to proceed in this, given the circumstances, again, given the lack of any felony history, and again, lack of any real assaultive history, and the treatment she's presently getting, that holding jail in abeyance is probably more appropriate. Even if it is longer than the 30 days, the court could hold 90 days in abeyance, and really give her an opportunity to continue and to show the court that she's on the right path. Because I do believe that she has made great strides in the treatment that she's in addressing her alcohol issue. And as we all know, time will tell. But I think that it is appropriate to hold jail in abeyance here, and hold her feet to the fire to continue to do the right things here. Honestly, one additional thing I wanted to point out, there's reference in the PSI made to an injury to the officer. I think that's somewhat mischaracterized in here. I mean, there is an injury that was sustained by an officer. It was a dog bite.
Can't tell me.
I mean, obviously, Miss Creed did not sick the dog on anybody or anything like that. The dog was, I think, aggressive towards the officers prior to any of this happening. And I mean, again, I'm not going to say that the circumstances here aren't made worse by Miss Creed's actions, right? I mean, they are. Frankly, I mean, this went from what was likely a misdemeanor investigation to a felony investigation because of that. But I think that to say that she caused an injury to the officer is not really an accurate depiction of what occurred there.
Okay. Ms. Creed, anything you wanted to say?
I apologize for my actions. Obviously, it is true. I've made it worse. I should have just complied with the officer and opened the door. The officer did get a bite or nip at his arm. I also got my leg tore up by it too. I've been going to counseling for my alcohol. I've been to rehab since. I did 14 days in rehab. I would have stayed longer, but they lost power. I'm going to AA every week. I'm going through mid-Michigan. I'm on something for alcohol. Can't remember the name of it right now. Yeah, just trying to deal with it. Trying to not, I've been sober since February, so nothing's happened since February. Been all clean drops. I drop every once a week. I've just been doing good and like to stay out of jail and keep on doing good. I just got my job back. Keep on working.
Well, I read through the report, I'm familiar with the facts of what happened here, just for your knowledge, and Mr. Trush, I didn't get from the report that you intentionally, sick the dog on the officers or something like that. What I got from the report is you were acting in a way that, was resisting the officers. They're trying to restrain you, and the dog probably is hurting you. The dog is proceeding to attack on you, and then bites the officers. In my view, it doesn't really matter whether you intentionally stick the dog on him or your behavior caused the dog to attack you and the officers. It's your behavior that resulted in injury to the officer. If you don't do that, then the chance that the officer is going to be injured is far less likely, or not at all. I do think that probation is absolutely appropriate here. I did read through the report. I agree that alcohol is an issue for you, and that you behave in ways that maybe you wouldn't behave in if you're sober. So I think probation to monitor that is absolutely appropriate. I hope that the steps you're taking to get that under control continue, because I think, as Ms. Koch indicated, your record is starting to build, and if you don't get a hold of it now, your penalties are only going to get more severe as you go forward. As it is for this incident, I think some upfront jail time is appropriate given your actions towards the officer here. I don't think you can behave in this way towards police and in a way that results in injuries to police without some kind of punishment for that. And frankly, I have up to a year in jail that I could get you. I think the recommendation is appropriate. I think some upfront jail time, short term, will provide a degree of punishment to you, but still recognize the efforts that you're taking to try and get hold of this problem. So I think the recommendation is appropriate in all of its terms. And again, I think given your actions towards the officer, given that an injury did result, that this is a case where jail time is appropriate. The court is going to place you on probation for a period of 1 year. The court is going to adopt as the conditions of probation all the terms and conditions listed in the report. The court is going to order that you serve 30 days in the Crawford County Jail with credit for 2 days served. Crime victims assessment of $130, court costs of $325, attorney fees of $350, $100 state cost, and $30 per month supervision fee while you're on probation. And this is as people of charges, those to be served concurrent to each other. You do have credit for 2 days served, if I didn't say that. You do have the ability to seek an appeal of this sentence. If you wanted to do that, you would need to file for that within the next 21 days. If you have additional questions about that process, Mr. Trush will be able to answer any questions that you have. So, anything further that we need to address from your side?
No, thank you.
Mr. Beers.
Nothing further, thank you. And Your Honor, if I could go and take care of those last few legal matters.
I'm ready, Mr. Clark.
Mr. Clark, if you'd like to come forward to the podium here, please.
She called you an asshole,
Who did?
that girl.
Yeah.
You could be calling a different case, or we're gonna go for it.
I think, maybe we need to take a short recess here
I
to figure out
understand.
what's gonna happen, so.
Okay, if you're gonna sit back down, it's nothing about you, it's about the case, okay?
We'll go on record in People versus Caleb Clock. This is file number 255442. Record should reflect Mr. Clock present here in the courtroom today. This is the date and time set for sentencing in this matter. If I get counsel put your appearances in.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Jason Thompson, I have defendant Caleb Clock.
Mr. Clock, you get an adequate opportunity to go through the pre-sentence
Yes,
report.
sir.
Talk to your attorney about that.
Yes, sir.
Mr. Thompson, are there any additions, deletions, or corrections to that report?
No, Your Honor.
Are there any challenges to the scoring guidelines?
No, Your Honor.
Ms. Copeland, do people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the scoring?
No, Your Honor.
People have any victims that wish to address the board?
Your Honor, I don't know what Mr. Clock's goals in his life are, but when somebody is lodged, in a-
Do you have any victims that wish to address?
No.
Allocation, please.
I don't know what Mr. Clock's goals here are. He was lodged in Shawano. You know, he's only 19 years old, but his criminal history is starting to add up pretty quickly with his juvenile record. This could have ended really quite differently. I don't know why he would behave in this manner. I think the recommendation is appropriate for the assaultive nature of this case. He did get a fairly good plea offer, taking into consideration his age. It probably won't happen again. So I would ask the court to follow the recommendation.
Thank you, Mr. Thompson.
Thank you, Your Honor. I do want to emphasize Mr. Clark's age. I want to emphasize the very difficult childhood that the court reviewed. He's under a court guardianship at this point. He's been in placement a lot of his childhood and now young adulthood. He feels very badly about this. He's always been completely straightforward with me. He's not someone who tried to prevaricate or put the blame on someone else. He's taken responsibility here. He has been approximately 3 months here. It's within actual recommendation, the guidelines here. As the court to consider time served at this point. I certainly agree that some probation would be appropriate following whatever jail time this court imposes. Thank you.
Mr. Clark, anything that you got to say today?
I would like to apologize to the people I hurt.
All right, I did read through the report, so I'm familiar with what happened during this incident. There's also a lot of information in that report about you and your background and your circumstances. And so I take all of that into consideration, determining what an appropriate sentence is. And looking at the guidelines here, which are 0 to 17, it could call for as little as no additional jail time, or it could potentially sentence you to prison. I don't think that's appropriate. But I do have concerns about your behavior in this case and in relation to a lot of the prior incidents as well. Because this was an assault offense, I do think jail time is appropriate. The recommendation is for 5 months. That's in the middle of the guidelines or lower third of the guidelines. I think it's a reasonable recommendation. I think it provides a degree of punishment for you for your behavior, but also recognizes some of the mitigating factors like your youth. And I think some of the problems that you've had, which lead to this kind of behavior. I also think probation is appropriate to provide a degree of oversight. So I think the recommendation is well crafted. The court is going to follow that. Probation for a period of 2 years. The court will adopt as conditions of that probation all the terms and conditions listed in the report. The court will sentence you to 5 months in the Crawford County Jail. You have credit for 92 days served. Murder, crime victim assessment of $130. Court costs of $325. Attorney fees $350. $68 state cost. $30 per month supervision fee while you're on probation. You have the ability to seek an appeal of this sentence, and Mr. Thompson,
I have those right here, Your Honor. Mr. Clark, you could initial this, indicates that you're acknowledging receipt of those. I want to fill out those 2 sheets, type them out. Signing this doesn't file an appeal, it just acknowledges that you received it. So take back if you choose to.
is there anything further we should address on this file today?
No, thank you, Your Honor.
Nothing further for the court record. Thank you. Caleb, you're gonna go back. Your Honor, I can't help but notice this creative appeal rights are sitting out here that not get taken care of.
It was a misdemeanor, so I gave her all rights verbally.
All right, I'll just get this back to the court.
Thank you. Mr. Schmidt, were you ready with your plan?
Yes, Your Honor.
People versus Daniel Knight. This is file number 255433.
Sierra Coke on behalf of the people.
Jim, I don't forget. Do we have a plea agreement in this file?
We do not, Your Honor. There has been an offer made. I've explained that to my client. I believe he understands it. He's indicated to me that he wants to have a trial this matter.
Okay. Ms. Coke, how many days of trial do you think we would need for this case?
If the defense is planning to call witnesses, well, I think we can still do it in one.
1 day.
Yes.
Mr. Hunt?
I think to be safe, it probably should be scheduled for 2, Your Honor.
Set up for a 2-day jury trial. Ms. Coke, do the people need any particular period of time to be ready to go to trial?
No, but I do have one issue to address when we're done.
Mr. Hunt, in terms of when the trial schedules it versus court schedules the trial?
How quickly do you anticipate it would be at this point?
60 to 90 days.
Okay, that should be more than adequate, Your Honor.
And then I will set this for a final status conference on the court's motion day prior to the trial date. That'll be the plea and motion cut off. So to the extent that there are any additional plea discussions, that would be the last day to enter into a plea. And to the extent either side has any motions, they would need to be filed and heard no later than the date of that final status conference. This was the other issue.
I got a message from my staff since we've been back on the record that said that Mr. Knight was supposed to test. They did 2 tests today and he couldn't produce enough spit to do so. I just asked that the court order stay here until he does a test today.
Yeah, sorry, I didn't mean to speak out. I'm sorry, I'll do it again.
Okay, so Mr. Knight, you can make sure that you get that adequately addressed before you leave the courthouse.
Okay.
All right. Any other scheduling matters, Ms. Coe?
No, thank you.
No, Your Honor.
So the court will send out notices for the date and time of the trial as well as the final status conference. And we'll go from there. That's all. Thank you.
Thank you,
Your
Your Honor.
Henning is here, Mr. Dick. Mr. Cutler.
Sir, are you Jared Cutler?
Yes, sir.
Okay. We're going to start your case here in just a minute. Mr. Cutler, your attorney is connecting in here.
Appreciate it.
Sorry about that, Judge. It took me a minute to figure out that button.
No problem. Okay, so we'll go on the record in People versus Jared Cutler. This is file number 214917. Record should reflect Mr. Cutler's present today by video from Charlevoix County Jail. His attorney, Mr. Burden, is present also by video. His co-host here in the courtroom.
Oh, sorry, give it to you.
Give me my name.
Yeah, sorry.
Mr. Burden, can you tell me where this file stands today? I know the court scheduled this hearing today in response to a letter it received from Mr. Cutler, who I believe has been absconded, and there's been a bench warrant out for a period of time, I think. So can you tell me?
Yes, this case originated back in 2021. I have had a conversation with my client, and unless he's changed his mind since we've had that conversation, it's my understanding that he wants to take advantage of the plea offer that was made to him in the original case. I have a signed plea sheet, and it identifies that he would be pleading guilty to an added count of domestic violence, with an understanding that counts 1, 2, and 3 would be dismissed, and there would be no objection to 76948 treatment on that file if he was eligible. And it would be his intention to accept that plea and under a factual basis today.
I do not object to that. I do not know whether or not he's eligible for 7694A. I wasn't sure at the time of it here, and I'm definitely not sure now because I don't know what's happened since, but it's not part of the plea agreement that he gets it. It's just, if he's eligible, I wouldn't object.
Okay, Mr. Vernon, is that consistent with your understanding?
It is.
Okay, so Mr. Cutler, the plea offer in this case is for you to plead to 1 count of domestic violence. The prosecutor would not object if you're eligible to a deferral, which would allow that if you successfully completed a period of probation and or jail, would allow that charge to come off. But that part of it isn't part of the plea agreement because we don't know whether you're eligible at this point. Do you understand that?
Yes, sir.
Did you wish to go forward with that plea agreement today?
Yes, sir, I do.
Can you raise your right hand, please? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
So help me God, I do.
Thank you. You can lower your hand. Mr. Cutler, by pleading guilty to this charge, again, whether or not you're eligible for deferral on probation, the maximum penalty you could face would be up to 93 days and or a $500 fine. Do you understand that?
Yes, sir.
With that penalty in mind, what is your plea to that charge today?
Guilty.
Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you want it. You understand all those rights?
Yes, sir.
You understand that you're giving up and waiving all of those rights by pleading guilty?
Yes, sir.
Has anyone threatened you with anything to get you to plead guilty?
No, sir.
Has anyone promised you anything other than what we've said on the record here in court today?
No, sir.
Is it your own free choice to plead guilty?
Yes, it is.
Are you pleading guilty because you are guilty?
Yes, sir.
This happened back on April 15th of 2021. Do you recall that day, even though it's been a number of years since then?
Yes, I do.
On that day, were you here in Crawford County?
I was.
Did you have an incident happen with a Hope Cutler?
Yes, I did.
How did you know that person, or how were you related to that person?
That person is my mom.
Okay. And I'm assuming, were you residing together at that point?
No, we lived just down the road from one another.
Okay. Had you had resided with her at some point in your life, though, I would assume?
No, sir.
Okay. Oh, or Mr. Vernon, I don't know. We need more than just a mother-son relationship here for domestic violence.
Mr. Cutler, when you were a child, did you live with your mom?
I guess for maybe like a year or two before I was adopted.
Okay. I think that's sufficient, Your Honor.
All right, thank you. And what happened with Ms. Cutler that would make you guilty of an assault?
We were having some drinks and we got into a little bit of a dispute and it turned into us pushing and shoving.
Okay. And when you shoved Ms. Cutler at some point?
Yeah. Yes, sir.
Was that something that was against her will?
I'd imagine it was.
Okay. Ms. Coker, are you satisfied with the factual basis?
Yes.
Mr. Vernon, are you satisfied with the factual basis?
I am.
Ms. Coker, are you aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Vernon?
I went over his potential penalties with him. I Obviously, there wouldn't be any guidelines on this, but I did explain to him the likely penalties based on my experience. I also informed him that my opinion of what the penalties are not part of the plea agreement. They're not binding on the court.
Okay. Ms. Koch, are the people satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Mr. Vernon?
I am likewise.
Mr. Cutler, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. How long are you going to be lodged there in Charlevoix County? Do you know?
I got 152 days. My out date is November 16th.
Okay. So we're going to set this matter for sentencing next month in October. You do have the right to be present here in Grayling for your sentencing hearing. And if you wanted to exercise that right, I would sign an order to have you transported here for the purposes of that hearing. You can waive that right and we can have your sentencing hearing by video as we're doing today. You know how you'd like to proceed in that regard?
My video works.
Okay, so we'll set this for hearing by video for sentencing. Ms. Koch, anything else that we need to address today?
No, thank you.
Mr. Vernon, anything further from your side?
No, Your Honor.
Mr. Cutler, do you have any questions at all?
No, sir. So we're just waiting to see if I'm eligible for the plea.
Yeah, somebody from the probation department will be in touch with you to do a pre-sentence report and they'll gather all that information and you should know prior to that sentencing hearing whether or not you're eligible.
Sound good. I appreciate it.
Okay, the court's going to disconnect at this time.
Thank you, Judge.
All right, Mr. Dick, are you ready on this Hennings case?
Yes.
We'll go on the record in People versus Amber Henning. Ms. Henning, do you want to come forward to the podium, please? Put your appearances on.
Sierra Coke on behalf of the people.
James Dick on behalf of Ms. Henning, who's standing to my right, Your Honor.
Okay, Mr. Dick, can you tell me where things are at?
Your Honor, we are still sort of in the plea negotiations aspect of this case. I did provide the prosecutor with some additional information that may perhaps affect how the outcome of this case is resolved. So we would ask if the court would provide us a brief adjournment to do so.
No objection.
Is 30 days going to be enough time, Mr. Dick?
Absolutely.
Ms. Koch?
That's fine.
So we'll set this for a plea hearing status conference in the next, at the next, court's next hearing date in 30 days. Between now and then, Ms. Henning, it's important to stay in touch with Mr. Dick and discuss any potential plea and that you be ready. Okay.
Sorry.
Ms. Koch, anything further we need to address today?
No, Your Honor.
Mr. Dick?
No, thank you, Your Honor.
Thank you, that's all for today.
Thank you.
People versus Baker, case number 255439. Baker.
Sierra Coke on behalf of the people.
James Dick on behalf of Mr. Baker, who's standing to my right, Your Honor.
Tell me the status of this file.
Yes, likewise, I received a phone call last night that may be pertinent to this matter that I have not had the opportunity to speak with the prosecutor on yet, but it may have some effect on the outcome of this matter, but one way or another, at the next hearing, we will have a resolution to this case. It will be resolved in a plea. However, we're just working on one of the particular charges that will be collected.
Okay, so Objection.
No.
Court will set this for a status conference plea hearing in about 30 days. As I told the previous person, Mr. Baker, it's important that you stay in touch with Mr. Dick over the next 30 days so that.
Thank you very much, Your Honor.
We'll take a short recess. Looks like Mr. Trush is still finishing up his. We'll come back on the record as soon as. I'm gonna go through those rights with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf here at trial. You have the right to remain silent during a trial, to not have that silence used against you, and the right to testify at a trial yourself if you want it. You understand all those rights.
Yes.
You understand that you're giving up and waiving all of those rights by pleading guilty.
Yes.
Also, you don't have an automatic right to appeal the plea that you're making here today. You can only appeal by leave. That means that you would have to ask for the Court of Appeals to hear your case. They could say no, and then that would be the end of any appeal. You understand that?
Yes.
Has anyone threatened you with anything to get you to plead guilty?
No.
Has anyone promised you anything other than what we said here in court today?
No.
Is it your own free choice to plead guilty?
Yes.
Are you pleading guilty because you are actually guilty of this charge?
Yes.
The information I have indicates that this happened on or about April 6th of 2025. Is that the right date range?
Yes.
On that day, were you present here in Crawford County?
Yes.
While you were here in Crawford County, did you possess some amount of methamphetamine?
Yes.
Did you know that that's what that was?
Yes.
Do you have any legal right to have any amount of it at that time?
No.
Let's go here. The people satisfied with the factual basis.
Yes, Your Honor.
Defense is satisfied.
Ms. Koch, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Church.
I'm aware of none, Your Honor.
Ms. Koch, are the people satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Mr. Church.
I am satisfied.
Your activity, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. And there'll be a pre-sentence report that's prepared. You'll have an opportunity to go through that with your attorney prior to the sentencing. That's scheduled.
September 11th.
So in light of the plea today, the court will adjourn the trial date set for September 11th. Ms. Koch, anything further we need to address today?
You know, we did have some notices and motions and such filed since we entered a plea. All of those are waived.
I agree.
Oh, all right, thank you. That's all for today. All right, People versus Duval, case number 255409. The registered reflects Mr. Duval present in the courtroom. Ready to move forward with this hearing. This is the date time set for sentencing. Mr. Duval, did you have an adequate opportunity to go through the pre-sentence report and talk to Mr. Church about that?
Yes, sir.
And this is a delayed sentence. But Mr. Church, I do want to make sure there's no, as of now, any changes.
I don't believe so. I did just want to make sure that I have it attached to the PSI here, but the court did receive the psychosexual risk assessment.
I did, and I did read that, right?
Okay, I just wanted to make sure it was actually attached to the PSI and not something I just stuck there.
No, it is, it was attached to my copy and reference.
No additions, deletions, or corrections.
And Joe, this is the score.
No, Your Honor.
Scope, do the people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the score?
No, Your Honor.
I do want to make a record here with regard to victim impact statements. I did receive a request for an individual to submit a written victim impact statement. The information I got was that that individual is a person or a relative of the person who involved in the complaint, or somehow connected to this case. I didn't get a lot of information about it. But that person was also a court employee. After reviewing the Crime Victims' Rights Act, I determined that individual wasn't someone that had a right to speak as a victim at sentencing. Regardless of that, the court does have the discretion to nonetheless allow that person to make a statement, either verbally before the court or in writing. I indicated that I would not accept that statement for several reasons. Number one, that person doesn't have a right under the Crime Victims' Rights Act to make a statement. Number two, while I had information that was reported, so I don't know who that was, but I have concerns, number one, about allowing someone who's a court employee to make a statement in this case because of the potential that it could be grounds for my disqualification and having to reassign this case. And I think just based on the limited knowledge I do have, maybe it still is. I'll make that inquiry with Mr. Church here in a moment. But number two, I didn't want there to be any impression by anybody involved in the case or the general public or the community that somehow the court's sentencing in this case or the court's agreement to the delay of sentence had anything to do with a statement made by someone affiliated with the court. So for those reasons, I didn't think it was appropriate. I declined to allow that. I don't know what that individual would have said, or again, even if it is other. But having made that record, Mr. Trush, is this something that you want to confer with your client on? Is this something that you feel we need to address in terms of disqualification or facing this?
I don't believe so. I know who the court employee is. I think Mr. Duval does as well. So I don't think there's any need for disqualification.
So
I would agree with Mr. Trush.
outside of that issue, Ms. Cope, do you have any other victims that wish to address the court?
They do not.
Anything by way of allocution on behalf of people?
Your Honor, I hate this case. Mr. Duval has no criminal history recently. His criminal history is 30 years ago. This was a horrible situation. What he did was horrible. It didn't progress into anything more than what's in the PSI, but it certainly could have went a different direction. I'm glad that the family members called. I did talk to the family or the victim mom about the plea before I made the plea offer and how the minor child was doing and whether or not she wanted to testify and explain the process. They were on board with the plea. I would ask the court to adopt the recommendation. Thank you.
Thank you. Mr. Duval has lived his life generally in the way that we would want to see someone live their life. Again, he has some history that's very old. I see this type of offer really as kind of a prove-it situation. Mr. Duval says this is not the person that he is, and he's going to have an opportunity to show the court that. This is a circumstance where I think it was a New Year's Eve party, and I think there was alcohol involved. And again, frankly, I think this is a circumstance where he has the ability to show the court that this is not the person that he is. And I think reflected in the risk assessment, likewise, I think it indicates this is not the person that he is.
Mr. Duval, anything you wanted to say to that?
I'd just like to say I'm sorry to anybody and everybody that's affected with this, and this is not who I am by any means, never has been, never will be. Appreciate the court's opportunity to prove that to you.
I did read through the pre-sentence report, so I'm familiar both with your background and history, as well as the circumstances that bring you before the court on this case today. That evaluation that was submitted. So looking at all the information together along with what you had to say here from lawyers, I think this is a fair resolution. I'm satisfied based on what I read in the evaluation as well as just your past history, which doesn't involve any offenses of this kind. And typically when somebody has some type of predilection or difficulty controlling those kind of urges, they end up getting themselves in trouble before they reach your age. So the fact that this hasn't occurred before indicates to me that there's a likelihood that this was a one-time incident, not a pattern of behavior on your part. And I think the evaluation supports that viewpoint. That being said, there's no question that this was completely inappropriate. Something that you do under the influence that maybe doesn't even mean that much to you or doesn't seem like that bad of a thing to you, at least at the time, has the potential, and I think in this case did result in serious long-term effects to the person who you touched. And to her, this was a big deal, and it is a big deal. Would be to anybody in the position. And so from that standpoint, I think you need to understand that this was wrongful conduct that you should not engage in again. I know you had a long period of sobriety. I think you need to go back to that because I think if you're under the influence, it creates the potential that you're going to do something you're going to regret later and harm somebody else process. And so I think there was an effect on the victim in this case. I think that deserves consideration. But I also think, given your lack of prior history, there's a reasonable expectation that you would not engage in this kind of again, and that this would be a wake-up call to you. Be careful about what you do. Touch. So I am going to go with the recommendation here. And the fact of the matter is, if you don't follow the terms of this delay, we'll be back here and you'll be looking at a much harsher punch. The court is going to place you on a term of delay of sentence for a period of 12 months. The court is going to adopt as the terms and conditions of the delay, all the terms and conditions that are listed in this report. So there's a lot of things in here that are going to restrict where you can go and what you can do. And you need to make sure that you're 100% clear on that with your agent so that you don't run afoul of this. Because later on saying, well, I didn't realize that or I didn't know about it. So you need to do whatever you do to make sure you need to make sure that you understand what you can't do with regard to the restrictions. The court is going to impose a crime victim's assessment of $130, court costs of $325, $68 state cost, supervision fee of $30 per month while you're on probation. Because this is a delayed sentence, there are no appellate rights at this time. Ms. Cope, is there anything further that we need to address for the record?
No, thank you.
Mr. Church.
Nothing further.
Mr. Haven, is calling to me before he leaves here today.
Yes, I've already spoken with him. We'll meet afterwards.
Okay. All right. Good luck to you going forward.
Thank you, sir.
And that concludes the court's morning docket. We'll be in recess until 1:30.
So the answer to that question is no.
Yes.